Today, we will hear testimony from our colleagues from the Judiciary Committee on 3 bills, starting with Senate Amendment to H.R. 8404, the Respect for Marriage Act. Right now, rights in this country are under attack. MAGA Republicans, extremist judges, and a number of activist Supreme Court justices are actively working to strip fundamental freedoms from Americans. We saw it earlier this year with the overturning of Roe versus Wade. They effectively turned back the clock on 50 years. It turned back the clock 50 years on a woman's right to choose. And they weren't shy to share that rolling back the right to marriage could be next. The Respect for Marriage Act is historic legislation to protect the marriages of same-sex and interracial couples. Democrats are fighting for this bill because we know that people should be able to marry who they love without the government getting in the way. And now I know some are celebrating the fact that this bill earned bipartisan support in the Senate. And while I'm glad that 12 Republicans recognize that no politician or activist judge should have the authority to tell Americans who they can marry, 36 Republican senators still voted against the bill. And many of them continue to spew, quite frankly, disgusting rhetoric against the LGBTQ community on their social media platforms and out to the public. The hate and discrimination that we have witnessed over the last few years is reprehensible, and that cannot be lost on us. We must remain vigilant in ensuring equal rights for every American and passing the legislation that is critical to this mission. And I want to ask unanimous consent to insert in the record the names of the 12 Republican senators that voted yes and the names of the 36 Republicans that voted no. Okay. Because I think for the sake of it. Okay. Well, let me read them then. So the 12 that voted yes are Senators Blunt, Burr, Capito, Collins, Ernst, Loomis, Murkowski, Portman, Romney, Sullivan, Tillis, and Young. And sadly, those who voted no are Barrasso, Blackburn, Bozeman, Braun, Cassidy, Cornyn, Cotton, Kramer, Crapo, Cruz, Daines, Fisher, Graham of South Carolina, Grassley, Haggerty, Hawley, Hoven, Hyde-Smith, Inhofe, Johnson, Kennedy, Langford, Lee, Marshall, McConnell, Moran, Paul, Risch, Rounds, Rubio, Scott of Florida, Scott of South Carolina, Shelby, Thune, Tuberville, and Wicker. And I think it is important for the record to reflect those names, the names of those senators who believe it's their right to interfere in the marriages of people in this country. I think it's reprehensible. We also have 2 immigration reform bills, H.R. 3648, the Equal Access to Green Cards for Legal Employment, or EAGLE Act of 2022. It begins to address the extensive green card backlog. The legislation eliminates per-country caps on employment-based visas and raises per-country caps for family-based visas to 15%. And H.R. 7946, the Veteran Service Recognition Act, improves naturalization for non-citizens who served in our nation's military. Aside from these 2 bills, I believe other urgent priority immigration issues also need to be addressed this Congress, ranging from permanent residency for Dreamers to providing secure and stable immigration for agricultural workers. Before we dive into testimony, I want to note that we also announced that we would consider the James M. Inhofe National Defense Authorization Act for fiscal year 2023 during this meeting. Bill text for the NDA package is not ready yet, but our committee remains ready to take it up as soon as the text is finalized. I look forward to today's discussion, and with that, I turn to the ranking member, Mr. Cole, for any comments he wishes to make.
Mr. Chair, if I could take 1 second. I want to recognize my wife, who's here after all these years. She wanted to see what we do in the Rules Committee, and you notice she was ready to leave when all of a sudden we were already in a confrontation between you and the gentlelady from Minnesota. So Nancy, my wife, thank you for coming today. She's a high school math teacher, Arvada West High School, just outside of Denver, Colorado, and you know, she waits until I'm ready to leave before she comes to see what I'm doing.
And thank you
So-
for dealing with him all these years. We appreciate it. Yeah. If you want to testify, we're happy to yield the floor to you. I'm happy now to yield to Mr. Cole.
Well, I want to welcome Mr. Perlmutter's much better half, no question about that, and we're delighted to have you here. And after you watch this, you'll wonder why he didn't leave sooner. But, thank you, Mr. Chairman. During today's hearing, we'll be considering three bills. The first I'll discuss is the Senate amendment to H.R. 8404, the Respect for Marriage Act. This bill will be somewhat familiar to this committee, given that we previously considered it at an emergency hearing in September. While the Senate's product is an improvement over the House version, I continue to have serious reservations about this bill and about the process we've followed to this point. The Senate had an opportunity to offer amendments and consider this bill in full on the floor, but no such opportunity was afforded to the House. This bill was not marked up by the Committee of Jurisdiction, was brought to the Rules Committee on just 1 hour's notice several months ago, and received a closed rule on the floor. Republicans in the House would have appreciated the opportunity to offer amendments to this measure. Indeed, I thought the Senate Republicans offered several thoughtful amendments that would have gone a long way toward protecting religious liberties, particularly Senator Lee's amendment prohibiting the government from removing tax-exempt status based on religious beliefs. And it's unfortunate that they were not adopted. But whereas members of the Senate received a fair opportunity to have an up or down vote on each of these amendments, members of the House did not. I find that deeply unfortunate, Mr. Chairman. Our other two bills both concerned immigration. Unfortunately, with these two bills, the majority is once again choosing to ignore the obvious crisis taking place at the southern border and in our immigration system. Since taking office, the Biden administration has amassed a sorry record on these fronts and has failed to secure the border and ensure that terrorists, drug traffickers, human traffickers, and violent criminals are being prevented from entering the country. We need bipartisan action today to help solve these problems and address these crises, and sadly, the majority's proposals today will do nothing toward that end. The first of these two bills I'll discuss, H.R. 3648, the EAGLE Act, would eliminate the per country caps for certain employment-based green cards and increase the limit on family-based green cards. While bipartisan versions of this bill passed both the House and the Senate last Congress with overwhelming support, unfortunately this year the majority has chosen to go it alone and has put up a partisan version of this bill. In particular, I'm troubled that the majority chose to take out a critical provision of the Senate bill, such as a provision banning the admission or the adjustment of status of aliens affiliated with the military forces of Communist China or the Communist Chinese Party, or the Chinese Communist Party. If we can all agree on one thing, surely it would be that the United States should not be allowing members of the Chinese Communist Party to receive adjusted immigration status in the United States. I find it astonishing the majority removed this common sense provision. Finally, our last bill is H.R. 7946, the Veteran Service Recognition Act. Broadly, this bill would create a green card path to citizenship for alien veterans, military service members, and their family members who are in the U.S. illegally or have committed other removable offenses. Unfortunately, the bill does not stop there, but additionally requires the adjustment of status of any non-citizen veteran who has been issued a final order of removal, regardless of the reasons for that removal. In particular, during the markup, the majority rejected several amendments Republicans offered to ensure that dangerous criminals, such as those convicted of crimes of domestic violence or drug trafficking, did not receive an adjustment of immigration status under the bill. Sadly, all those amendments were rejected. The failure to improve this bill to ensure that dangerous criminals were excluded is yet another example of where the priorities of this majority lie. Despite ample evidence in front of their very eyes, both this majority and the Biden administration have failed to address the crisis at our southern border and have failed time and time again to ensure that violent criminals do not gain entrance to the United States. Today's bill was an opportunity to take a step toward making this country a safer place, but the majority seemed fit to reject that option. I urge them to rethink their course, and with that, Mr. Chairman, I yield back.
Thank you very much. Ranking Member Cole yields back, and I'm thankful for his opening. I'd like to welcome our witnesses to provide testimony on the Senate amendment to H.R. 8404, the Respective Marriage Act, H.R. 3648, the Eagle Act of 2022, and H.R. 7946, the Veteran Service Recognition Act of 2022. Chairman Nadler, Representative Fitzgerald, and Subcommittee Chairperson Lofgren, we're delighted that you're here. I would now recognize the gentleman from New York, Mr. Nadler.
Thank you very much, Chairman McGovern, Ranking Member Cole, and members of the committee. Thank you for the opportunity to speak in support of the Senate amendment to H.R. 8404, excuse me, the Respect for Marriage Act. Thank you. I first introduced the underlying legislation in 2009. During this Congress, I introduced an amended version with the co-chairs of the LGBTQ plus Equality Caucus, the chairs of the Congressional Tri-Caucus, and incoming House Democratic leader Hakeem Jeffries. This version passed the House in July with the support of 47 Republican members. I find it deeply poignant that as we prepare to bring the 117th Congress to a close, we are on the cusp of a great bipartisan moral victory in the defense of the fundamental right of all Americans, a victory that will provide stability and reassurance to the millions of LGBTQ and interracial families that have come to rely on the constitutional right to marry. As a quick reminder, the Respect for Marriage Act does three things. First, it repeals the so-called Defense of Marriage Act, which blatantly discriminates against same-sex couples and still officially remains on the books. Second, it enshrines marriage equality for federal law purposes, requiring the federal government to consider a person to be married if the marriage was valid in the state where it was performed. Finally, it prohibits anyone acting under color of state law from denying full legal effect to a valid out-of-state marriage based on the sex, race, ethnicity, or national origin of the two individuals in the marriage. The Senate amendment does not change any of these substantive provisions. Rather, it adds language that explicitly affirms that existing constitutional and other legal protections for religious liberty remain in effect. The Senate amendment does not create any new substantive legal rights, but clarifies that the bill does not affect the existing legal rights or benefits of religious persons or entities. It also explicitly clarifies that the bill does not require or authorize the federal government to recognize polygamous marriages. It is because of this compromise, the result of the hard work of Senators Tammy Baldwin and Susan Collins, that the amended bill passed the Senate by a vote of 61 to 36, with 12 Republican senators voting in support. While marriage equality remains constitutionally protected today, we have learned in recent months that rights once thought to be fundamental and forever secure can in fact be taken away. Even if one accepts the Supreme Court's assurances that the constitutional right to marriage equality is settled law, Congress must use this opportunity to provide additional reinsurance to the many American families who have come to rely on this guarantee. The Respect for Marriage Act cements respect for married couples, which all Americans, including those in this Congress, should support and value. I should remind everyone that Justice Thomas, in his concurring opinion in Dobbs, invited the courts to revisit Obergefell and said that the underlying logic of the court's decision in Dobbs would undercut Obergefell. And therefore, we need this bill just in case that were to happen. I urge you to support the Senate amendment to H.R. 8404. I'd be happy to answer any questions you may have.
Well, thank you very much. I now recognize the gentleman from Wisconsin, Representative Fitzgerald. Welcome.
Thank you, Mr. Chairman. We're here today discussing three bills from Judiciary Committee. I'll first address the Senate amendment to H.R. 8404 before addressing H.R. 3648 and H.R. 7946. We're here discussing H.R. 8404, the Respect for Marriage Act, for a second time. Just as was true the first time, this bill is based on a false premise. The ability of same-sex and interracial couples to enter into marriage is not under threat. Contrary to Democrat fear-mongering, the Supreme Court is not poised to overturn its opinions in Obergefell and Hodges and Loving versus Virginia. Democrats have conjured up this non-existent threat based on one line in Justice Thomas's concurrence in Dobbs, and they are misunderstanding or deliberately misrepresenting what he said. Justice Thomas made the same point that he has made for years, that the collection of rights secured by the doctrine of substantive due process is better understood as being a function of the Constitution's Privileges and Immunities Clause. That's it. From his statement that a body of law should flow from one place in the Constitution instead of the other comes the hyperbolic arguments that we've heard about the necessity of this bill. Even if the court were to overturn Obergefell, marriage is a state issue. Aside from the flawed arguments about the necessity of this bill, it is worth examining why we are here discussing this bill for a second time. We are returning to this bill because of the disastrous way that this was brought to the floor for the first time. There was no hearing and there was no markup in the Committee of Jurisdiction. There was no debate in the Judiciary Committee about the text. There was no chance for amendments. This bill was introduced on the same day it was considered in the Rules Committee for the first time. The text was posted roughly 1 hour before the committee met. The House voted on this bill the next day. Because of this haphazard process and the significant and weighty issues that it touches on, the Senate was forced to make considerable changes to the bill. However, these changes do not go far enough. For example, the Senate amendment does not protect a private entity that is determined to be a state actor as a result of the services they provide on behalf of a government. These entities could be adoption agencies, shelters, or other service providers operated by a religious organization under contract with a city or state. If any semblance of regular order had been followed in the House, perhaps these problems could have been avoided. If there had been a markup in Judiciary Committee, Republicans would have offered serious and thoughtful amendments addressing many of the same issues. However, we were deprived of that opportunity. We are again left with a bill that the House Republicans had no role in drafting. We had no opportunity to provide input. I'm not telling anybody on this committee that's not the way to function, but certainly I think everybody would agree with that. Turning to the immigration bills, H.R. 3648 and H.R. 7946, I would first like to share some numbers with you. 4 million. That is the number of illegal border crossers encountered by the U.S. Customs and Border Protection along with the southwest border since President Biden took office. 1.4 million. That is the number of illegal aliens released into the U.S. interior by the Biden administration since President Biden took office. 1 million. That is the number of known gotaways who have successfully crossed the southern border since President Biden took office. And 856. The number of alien deaths along the southern border during the fiscal year of 2022. It's the highest ever annual number on record. 98, this is the number of alien terrorists encountered by the Border Patrol along the southern border during the fiscal year of 2021. It is nearly 9 times the number encountered between fiscal years 2017 and 2020 combined. If my Democrat colleagues are concerned about any of these numbers and the devastation the border crisis is causing to border communities, they have a funny way of showing it. They have chosen once again to push immigration legislation that completely ignores the unprecedented and unmitigated disaster that the Biden administration's policies have caused along our southern border. My Democrat colleagues should move legislation that will deter aliens who are thinking of coming here illegally and that criminal cartels have helped along the way. If my Democrat colleagues cared about the suffering of those trafficking across the border or the dangers posed by drugs flowing across the border, they would act to close the border. They would act to deter, not incentivize illegal immigration. Instead, my Democrat colleagues have brought us here today to move legislation that makes exceptions to the rules for aliens who have violated our laws. That floods the labor market with foreign workers to the detriment of American workers. And that ensures the Chinese Communist Party will have an avenue to continue its theft of our intellectual properties and sensitive technologies. Americans can breathe a sigh of relief that the Democrats will no longer control the House legislative agenda a few short weeks from now, but on their way out the door, Democrats are trying to go and do even more damage to our immigration system. And so this week, the House will focus and force votes on H.R. 3648, the EAGLE Act, and H.R. 7946, the Veteran Service Recognition Act. Under current law, the number of green cards in the employment-based categories and in the family-based categories that nationals of any one country can receive in a given fiscal year is limited in order to ensure that nationals of the few countries do not receive all of the available green cards in that year. That limit is 7% of the green cards available in that year. As a result, nationals of countries that reach the cap must wait until a later year for their green card to become available. The practical effect is years of long waiting and a long wait for green cards for aliens from certain specific countries. Many members of the House have previously supported legislation to eliminate the annual per country cap on employment-based green card issuance and raise the cap on family-based green card issuance to 15%. However, the bill text is now different because last Congress, the bill garnered opposition from both Democrats and Republicans in the Senate. The bill before us today reflects a patched-together version of the provisions insisted upon by any senator who happened to have a hold on an earlier version of the bill that prevented passage by unanimous consent last Congress. However, many Democrat colleagues purposely left out a few provisions they didn't like. Specifically, H.R. 3648 does not include provisions insisted upon by Senator Rick Scott to prevent aliens with ties to Chinese military or the CCP from receiving green cards, and to ensure the green cards issued each year are not all used by hundreds of thousands of H-1B visa holders in the U.S. In addition to the different texts, circumstances are now different. Back in 2019, the national security threat from Communist China was not as well known. However, officials in the Trump administration exposed the very real threat. They implemented policies to prevent the CCP from abusing our immigration system in order to steal our intellectual property and sensitive technologies. According to the Washington Post, one such initiative resulted in the arrest of 6 Chinese researchers accused of lying on their visa applications about their ties to the People's Liberation Army, and more than 1,000 researchers who had hidden their affiliation with the Chinese military, fleeing the United States within just a few short months. Unfortunately, H.R. 3648 will make it easier for the CCP to abuse our immigration system and steal our trade secrets and technology. The bill ensures that nationals of the 2 countries with the longest wait times for green card issuance will receive the overwhelmingly vast majority of green cards over the next several years. Those countries are China and India. Nationals of the other countries will be virtually shut out from their ability to get a green card for years to come. If you don't believe me, just listen to one Democrats' immigration special interest group, the American Immigration Lawyers Association, ALA, which opposes H.R. 3648. ALA notes that many applicants will now face longer wait times. The practical effect of H.R. 3648 will be that virtually every Chinese and Indian national who is currently waiting for a green card to become available will have to be issued their green card before an Australian or Kenyan or Brazilian or British or nationality of any other country that can get a green card. The CCP understands this and no doubt is rooting for H.R. 3648 to become law. The CCP is especially set to be rewarded in this employment-based fifth presence, EB5 category, if the bill becomes law. CCP money has long been used to fund EB5 investment projects in the U.S. Because this bill does not include a transition period for the EB5 category, the nationals of the country with the most nationals waiting for green cards in this category will immediately begin receiving all green cards. In the case of EB5, that country is China. I understand the idea behind Chair Lofgren's push to eliminate the cap, but we cannot ignore the practical national security implications of such an elimination, nor can we ignore the unfair implications of the per-country cap elimination. H.R. 3648 as currently drafted would result in the immediate exclusion from green cards of special immigrant religious workers from around the world for the next few years. Instead, unaccompanied alien children from the Northern Triangle countries who crossed our border illegally and are seeking special immigrant juvenile green cards will get those green cards first. This is because the bill does not contain a transition period for the employment-based fourth preference category. Again, Allah agrees, noting that the EAGLE Act will particularly harm religious workers. Also of particular concern is Section 7 of the bill, which was added at the insistence of Senator Dick Durbin. The provision is an end run around the annual green card limits. It allows certain temporary visa holders to file an application for adjustment for status despite the fact that no green card is available to them. The result is that many temporary visas will essentially become permanent because the alien visa holders will be able to live and work in the U.S. as if they had a green card. Of course, this will further strangle the ability of Americans to get good-paying jobs in tech and other sectors. If Congress wants to raise the overall annual green card limit, then that is what Congress should do. We should not instead create special green card-like treatment for certain aliens. As if the EAGLE Act was not bad enough, many Democrat colleagues also are intent on passing H.R. 7946, the Veteran Service Recognition Act. A poorly named bill, by the way. My Democrat colleagues have been persistent with a legislative strategy of targeting sympathetic populations to slowly erode the fair and even-handed enforcement of U.S. immigration laws. H.R. 7946 continues that effort by focusing on military service members, veterans, and their families. U.S. law allows foreign nationals who are lawful permanent residents or who the Secretary of Defense deems to be, quote, vital to the national interest, unquote, to enlist in the Army. According to the Department of Defense, just over 31,000 foreign nationals currently serve in the active duty and reserve U.S. military forces. The Immigration and Nationality Act contains provisions that ensure foreign national service members have the expedited ability to become U.S. citizens. In fact, since its creation in 2002, U.S. Citizenship and Immigration Services has naturalized over 148,000 members of the U.S. military. But some foreign national service members chose not to naturalize, and some commit offenses that make them removable from the United States. In those cases, U.S. Immigration and Customs Enforcement has in place a robust totality of the circumstances and the procedures, which must be followed prior to the initiation of enforcement actions such as their arrest or removal. It is important to note that prior to removal, an alien veteran is afforded due process through immigration removal proceedings, and a final order of removal is issued by an immigration judge. However, H.R. 7946 takes that decision about which aliens should and should not be subject to removal out of the hands of trained immigration officials and hands it to an advisory committee of people appointed by the Department of Homeland Security Secretary. This is the same secretary, Secretary Mayorkas, who, in the face of 4 million illegal border crossings so far during his tenure, had the audacity to tell House Judiciary Committee members under penalty of perjury that there was operational control on the border. Secretary Mayorkas, who continues to put policies in place that enrich the smuggling cartels by enticing foreign nationals to come to the U.S. illegally, is blind to this issue. And it is the same Secretary Mayorkas who issued guidance to ICE and CBP that required immigration officials to ignore the removal laws that Congress wrote. A federal judge enjoined implementation of that guidance, but now the Democrats are pushing to put the same kind of policies in statute with H.R. 7946. Under the bill, the advisory committee can recommend that an alien veteran, military service member, or family member not placed into removal proceedings despite convictions for domestic violence, drug crimes, and even for DUIs, which was an amendment offered in the Judiciary Committee. Remarkably, the only reason the bill doesn't allow the advisory committee to recommend that DHS not remove an alien with a conviction for murder, rape, or sexual abuse of a minor is because a member of the Rules Committee, Mrs. Fishbach, offered an amendment in the committee. My Democrat colleagues recognize the terrible optics of opposing the Fishbach amendment. If she hadn't offered the amendment, murderers, rapists, and child sex abusers would have been eligible too. The bill also provides a green card path to citizenship for alien veterans who have had their due process in immigration court and were issued a final order of removal by an immigration judge. These individuals can get a green card despite convictions for serious offenses such as illicit trafficking in firearms or explosives, trafficking controlled substances, domestic violence, unlawful voting, and international child abduction. Republican members offered several amendments during the markup to preclude aliens with these convictions and others from receiving a green card under the bill. My Democrat colleagues opposed each of these amendments. Also concerning is that the alien veterans who can get green cards under this bill are not required to have been honorably discharged from the military. They are only required to have been discharged under conditions other than dishonorable, which, as any current or former member of the military can tell you, is not the same thing as being honorably discharged. Discharges under any other honorable condition can include those for security violations, use of violence, and conviction by a civilian court with a sentence, including prison time. Mr. Issa offered an amendment in committee to require veterans who get green cards under this bill to have been honorably discharged. My Democrat colleagues opposed it. H.R. 7946 and H.R. 3648 are simply last-minute attempts by my colleagues on the other side of the aisle to appease immigration advocacy groups in a few short weeks left on the Democrat House majority. These bills will not improve our immigration system, they will not secure our southern border, and they do nothing to address the Biden border crisis. I oppose them, and I would yield back.
Well, thank you very much, and I just want to say for the record, I'm a member of the Democratic Party, and my colleagues are members of the Democratic Party. Whatever. Ms. Lofgren.
Thank you, Mr. McGovern. Today, we're going to take some important steps forward on these two bills, the EAGLE Act and the Veteran Service Recognition Act. Let me go into them one by one. First, the EAGLE Act is a bipartisan bill, and it raises the per-country caps on family-sponsored immigration visas and phases out over a period of 9 years per-country caps on employment-based immigration visas. The bill also includes significant improvements to the H-1B visa program that adds protections for U.S. workers. I think it's worth thinking back to how this whole system works. On the employment side, in order to be eligible for an employment-based visa, the employer has to advertise and prove that there's no one here that can do the job that you've been offered, in which case a labor certification is provided and you can seek a visa. That's merit-based. Here's what happens after that. Once that merit-based process is undertaken, then the visas are allocated based on where you're born, really contrary to how we operate in America. We should be based on merit, not where we're born. I will say this goes back a long time, really, to the 1965 Act, when I think our attitudes were very different than they are in this year about birth versus merit. We failed to update this, and as has been mentioned, there have been backlogs that have now grown up because of large countries that have a lot of highly educated individuals who have passed through that gauntlet where the employer proves there's no one here to do the job you're being offered. I would note that about 25% of the MDs in the United States are foreign-born, and they are serving in areas that are underserved, rural areas, inner-city areas, and the large percentage of them were born in India, Indian doctors who are providing health care, and if those individuals, if those doctors cannot get some stability in their life, they will go elsewhere. In Canada, you can get the equivalent of a permanent residence visa in under 6 months. Now, because of these backlogs, we've got individuals who are facing a delay in a permanent residence visa that it extends beyond their lifetime. And so as their children who are dependent visas hit 21, they've grown up in the United States, they're told to return to their origin of birth, whereas their parents are legally remaining on a temporary visa in the United States. And in fact, 95% of the individuals, or better, who would be impacted by this in 9 years are legally present in the United States working on temporary visas. Now, the idea that we would lift these per-country caps isn't new. There was a version of this legislation that passed the House in 2011 when our former colleague, Congressman Chaffetz of Utah led the effort, and it passed on suspension. Each time this has been considered on the floor, it's got more than 350 yes votes on the House floor. I think the changes that have been made are important ones. We have, as I say, additional restrictions to protect American workers and a longer 9-year transition period to make sure that no countries are excluded from receiving visas while the per-country caps are phased out. The Congressional Research Service, at our request, analyzed the bill and stated that no one currently in line would be negatively impacted by this legislation. I want to note a couple of other things because they've been raised. It is true that Senator Scott and the UC amendment in the last Congress added a prohibition on anyone who had ever been a member of the Communist Party. Well, why was that not accepted? It's because there are individuals who are involuntarily made a member of the Communist Party. For example, if you're a college student, whether you want to or not, you are considered a member of the Communist Party. Now, the prohibition in the act already exists. In the Immigration and Nationality Act, Section 212A, it says that if you are any immigrant who has been a member of or affiliated with the Communist or any other totalitarian party is inadmissible. So it's already covered, but there's two exceptions. If it's an involuntary membership, like you just got your name in it, but you didn't mean to be there, or if it's past membership that is no longer valid. For example, in Russia, it used to be that they would make, young children members of the Communist Party, and yet it wasn't like a solid decision they were making. That's what the state decided. So there are some exceptions that make sense, but the broad prohibition is if you're a communist, you're not admissible to the United States. So what the senator drafted was inartful and would have prevented people who have nothing to do with communism from at least having their case considered. And that's why we have stuck with the Immigration and Nationality Act. We're not for communists getting visas, and it's covered in the Immigration and Nationality Act. I would like to note also that we've had the CRS take a look at some of the other issues that have been raised. They assure us that they do not believe that there would be much, if any, adverse impact on the Religious Workers Program, and that in fact, the unaccompanied minor child program, the orphan program in EB4, would actually be eased up under this bill. The EB5 issue is addressed because 32% under the new regulations would be allocated to other visas, so I think the concern is not well placed. I would just like to say that I think we ought to do more to reform the H-1B program. This is probably not the vehicle for doing that, but we do have a ban on recruiting primarily H-1B workers for open positions, a ban on advertising only to H-1B workers, a significant increase in fines for violations of U.S. worker protections, an expansion of the Department of Labor's authority to audit and investigate employers of H-1B workers, and a ban on companies with 50 or more employees from obtaining additional H-1B visas if 50% of their workforce are on H-1B or L-1 visas. Those reforms were suggested by a bipartisan team in the Senate, and that's Dick Durbin and Senator Grassley, and we agree. Those reforms can easily be included into this. I just think that when you think back about who we are as Americans, we're for merit, not for race-based visa allocation. And when all is said and done, that's what this bill does. I want to talk briefly about H.R. 7946, the Veteran Service Recognition Act, because it's another important piece of legislation. It ensures that our non-citizen service members, veterans, and their families are treated with the fairness and dignity that they deserve. Our immigration laws promise citizenship for those who serve in our armed forces, but unfortunately, we found that some of the members of our armed services got bad information or had misunderstandings about their status. We have talked to individuals who thought when they joined up, they became U.S. citizens, and were so shocked to find out they were not, merely through their service. I think what the provisions of the bill that really ask our Department of Defense to do a better job of helping members of the armed services naturalize will help that prospectively. But we have a situation where individuals were removed from the country, veterans, before they became U.S. citizens. Many times, these removals were due to a conviction for a crime stemming from trauma that occurred during the veteran's military service. For example, we all know that PTSD acquired in wartime can have a very serious adverse impact on individuals. And in fact, sometimes PTSD victims self-medicate. They might use alcohol or drugs to deal with the trauma that they have received in their service. That, of course, will run them afoul of the law, and if they're not yet a U.S. citizen, will lead to a deportation. So you have a situation where individuals who fought valiantly in war for our country, for their country, are deported instead. And in fact, there's a whole group of individuals, veterans of the U.S. military, who are camped outside of the United States at the border with their American citizen wives and children here on this side of the border. The trauma for them, obviously, is multitude. First, they have gained access to veterans' benefits, including health care benefits, but they can't access those benefits from abroad. I think, the comments made about general discharge were greatly discussed and was done intentionally, because if you have a PTSD trauma and you start using drugs while you're in the service, you may get a general discharge from the Army, and it could be connected with the trauma that you have encountered in your service. I would like to just note that this bill also provides for an advisory committee that is made up, is supposed to be made up of Military Family Advisory Council. And these are individuals who are supposed to be alert to the issues relative to military service. They don't have a decision-making authority, but they are asked to review situations of military members who are immigration proceedings and to be able to dig in to the facts of that individual's case that an immigration judge may not have the time to do. They're then able to provide the immigration judge the information. The judge then, under the law, may either accept the recommendation or may reach a different conclusion. But it's advisory only, but it is intended to provide more information in this whole process. Additionally, 7946 would codify the military parole in place for the immediate relatives of U.S. citizen service members and veterans. This is a long-standing and bipartisan initiative which began in 2007 under George Bush. We had a situation where you had an undocumented mom, her U.S. citizen son was killed in active duty, and then she was deported. That was something that President Bush didn't find acceptable, President Obama didn't find acceptable, we don't find acceptable, and it allows for that travesty to be avoided. I would just like to say that the bill is supported by a lot of groups, including the American Legion, the nation's largest veterans service organization. I think it's time for us to commit to our service members and veterans to honor the promise our nation makes to non-citizens who serve in our armed services. I do think that these bills should move forward. I do think that the support of the American Legion, along with the Iraq and Afghanistan veterans of America and the veterans for American ideals, should be meaningful to us. These are not necessarily groups that come on board on immigration measures of all sorts, but they understand the importance of standing up for American veterans. I think both these bills are worthy of our support. And, you know, we can disagree on a lot of things when it comes to immigration, but one of the things I think is problematic is to say if there is any disorder at the border, and there is some disorder at the border, we need to have a more orderly system. In order to have a more orderly system, you have to amend the immigration laws. To say that we're not going to do anything to make this system work because it's not working is circular and really a bad idea. So these are two modest steps forward. I hope that we can support them here in the committee and on the floor, and I'd be happy to answer.
Thank you very much. Thank you all for your testimonies. Chairperson Lofgren, can you please share with us why the recapture of green card visas is not included in the EAGLE Act, which is, I know, something that you've supported and viewed as needed if we're going to seriously address the green card backlog?
Well, it's something, the recapture of visas is something I support, as you've mentioned, for a couple of things. One, I mean, the Congress intended that a certain number of visas be allocated each year. The only reason why they are not distributed is bureaucratic failures. And so the argument for recapture is a sound one, but it's not one that we got support for in the United States Senate. And so that's why it's not included. We want to get something passed. We want to get something enacted into law. There's a lot of things I'd like to do, but I'm trying to do something that is achievable in these two bills, and that's the main reason.
Thank you. And let me just say briefly, because I don't want to take very much time here, on the Respect for Marriage Act, I think it's important to state for the record that the Senate amendment protects all religious liberty and conscience protections available under the Constitution or federal law, including but not limited to the Religious Freedom Restoration Act, and forbids this bill from being used to diminish or repeal any such protection. But I just also want to say that I am not calmed at all by the notion that somehow we shouldn't worry that the Supreme Court has no intention of going after marriage equality in this country. If I recall, many of the Supreme Court justices that voted to overturn Roe versus Wade and gave us this terrible Dobbs decision, which turned back the clock for women's rights in this country, reassured senator after senator after senator that Roe was established precedent, and they had no intention of reversing it. Not just Democratic senators, by the way, but Republican senators too. And we've heard the concern by some Republican senators, you know, who were shocked by what the Supreme Court decided. And so, you know, there's an old saying, you know, fool me once, shame on you. Fool me twice, shame on me. And I think, you know, Clarence Thomas, you know, gave us a preview of his thinking. You know, I think we ought to look at that as a signal that marriage equality could very much be under threat. And I want to commend the Republican senators who joined with the Democratic senators in voting for this amendment. Boy, I think it's the right thing to do, and the fact that it's controversial is just hard for me to believe in the year 2022. But having said that, I appreciate everybody being here. I yield to the gentleman from Oklahoma.
Thank you very much, Mr. Chairman. Mr. Fitzgerald, given the threat that China poses to our economic and national security, I'm astonished in some ways that we're dealing with H.R. 3648. I understand that on Friday evening, Chairman Nadler submitted a manager's amendment that I presume this amendment attempts to alleviate some of the well-founded, significant concerns that my colleagues articulated during the Judiciary Committee. Have you had an opportunity to review that amendment? And if so, do you think it improves the bill in substantive ways?
Yeah, thanks for the question, Mr. Cole.
Right.
So the manager's amendment is our Democrat colleagues' answer to an amendment that our colleague from North Carolina, Mr. Bishop, offered during the markup. And it basically goes back to, I think, what we were discussing earlier, which is an alien who is affiliated with or is a member of the Chinese Communist Party from being issued that H-1B visa. And I know it was said before that, well, you know, that the party mandates membership for certain sectors of the Chinese population. But if that distinction could be made, I think certainly that would be part of any process. So it should be noted that the amendment is specific to H-1B visas, I think, and that's what Mr. Bishop was trying to do.
And let me follow up a related question.
Ms. McCall?
We've had some discussion of the Senate passed amendment authored by Mr. Scott to prevent Chinese nationals, I should say Rick Scott, so there's no confusion, prevent Chinese nationals with Chinese military or Communist Party background from adjusting their status. Do you agree that there's something inartful or flawed in that amendment?
I do, and I think specifically the CCP in the language contains the exceptions, and I think that's, you know, once you get into that area, it becomes very murky and very gray about what would and what wouldn't be allowed. So I would agree with that.
Okay, and let me turn now to 7946. I understand that Republicans submitted a number of important amendments during the committee markup, and Democrats blocked virtually all of them. As a result, is it possible for violent criminals, including fentanyl traffickers, to exploit the provisions in this bill and actually gain a path to citizenship?
The answer is yes, and if I recall in judiciary and the discussions that happened there that day, what Republicans tried to do was offer very specific types of categories or groups or individuals that fit those categories to kind of display, I think, to everyone that there were going to be very specific circumstances that needed to be addressed, and they weren't. So it's too broad. It's encompassing too much. It's bringing too much in at one time, and I think that's what the amendments we offered did.
Okay, and finally, given the security and humanitarian crisis at our southern border, something you discussed in your remarks, and a crisis that'll frankly be exacerbated when Title 42 expires this month, and that's not just a Republican concern. We actually have Democratic senators who have raised that issue in a letter to the president. Democrats are rejecting in H.R. 3648 important bipartisan language in prioritizing the needs of China over the security of our country. And in H.R. 7946, Democrats are jamming through a bill so riddled with loopholes and unaccountable bureaucratic constructs that it'll do little more than weaken our national security and undermine the sacrifices people made that it purports to help. Do you have any final comments you'd like to make before I yield back?
Just I think there was support amongst many House members to abandon the 15%, but if you look at the bill text now, it's different, and the reason for that is because it just couldn't garner enough support, apparently. So the effect of H.R. 3648 will be that every Chinese and Indian national who is currently waiting for the green card, and I think I said this in my opening statement, will now be able to get a card, but it might be issued by a different country. And I think, once again, that's a workaround, and it's not something that I think many members would support. And that, to me, it seems like a bipartisan issue that there would be opposition based on that specific item.
Okay, thank you. Thank you, Mr. Chairman. Yield back.
Mr. Perlmutter?
Just a couple points. And Mr. Fitzgerald, I'm your Democratic colleague, please. And, you know, I don't call you the...
I'm sorry if I misspoke, because that's the fastest I've ever read an opening statement.
All right, no,
That
and
was
I
the
appreciate
edited version too. So.
No, but thank you. But just so you know,
Yeah.
that does,
Yeah,
you know, it's
yeah.
like fingernails on a chalkboard on
Gotcha,
that kind of stuff.
gotcha.
So, just a couple things. Ms. Lofgren made the point, and, you know, since I've been practicing law a long time, you know, that blanket Communist Party thing has been a part of our immigration laws forever. And so I don't know that the objection that you raised really, does much. It's in the law, and I don't know what Senator Scott was trying to accomplish with his amendment or not, but I mean, that's already in there, and the immigration and naturalization and the Border Patrol, I mean, that's something they've looked at for 60 or 70 years, since the World War II. So, I mean, what is it that you just think it needs to be more specific, or what are you driving at here?
Well, I don't think that was until today, I was unaware that there is kind of this blanket exception. So maybe that's something I missed in the judiciary hearing when it happened. I'm not sure what the mechanism is or how that works, but there must be a way of identifying that, I would think, between a Chinese college student and somebody that's actively operating and isn't
As part of the
operating
party.
within the CCP.
And
I don't know that, so.
Okay. Ms. Lofton.
Yeah, that's the very point that we were trying to make. Senator Scott's, of Florida's proposal basically said if you were a member, a communist member, and you're Chinese, you're excluded, whether you were 12 years old, whether you didn't even know about it, whether it was involuntary. And I think that's not as carefully crafted as the provision of the law, which we did talk about in committee, 212A-D3E of the Immigration and Nationality Act, which excludes members of the Communist Party. But if you were, there are some ways, if you didn't know it, it was involuntary, it was so long ago, you're a child. I mean, so that at least you can have some rationality to this. It excludes, the gentleman mentioned some people who were excluded. Good. We don't want the Chinese military over here stealing our secrets. And this provision of law gives us the capacity to get rid of them. So there's no disagreement on that. The question is, what do you need as a legal tool? I think we have a good legal tool in the law today. It's just a matter of enforcing it. And honestly, for people who are against, and we've got people demonstrating in Hong Kong, we got people demonstrating against the communists to the extent that we can take anti-communist Chinese talent and weaken China. That's to the good for us, I'd say.
Second point and last point is, and this is more of a sort of just my own view of the world, that if somebody serves our country, and they put their lives on the line, that they've now reached a different level now, and they should have the benefit of being part of our country. Now, if they're criminals, they go to jail, but not necessarily deported. So I guess that's how I've been looking at this as these things have come up over the years. That somebody serves us, is a veteran, has served in our military, okay, they've gained a higher status in my eyes, and I think in the eyes of the country. Now, if they're doing things that are violating our law, well, we got plenty of things and places for them to go. But they've risen to a higher level, and I think, and maybe you look at it differently than I do, but that's how I've been viewing this for the last few years. Mr. Fitzgerald, that was directed to you.
Yeah. So, I mean, when we had this discussion, and I guess having a little bit of being familiar with kind of the way it's, so if somebody enlists, they show up at the recruiter's office, they enlist, and there's a series of questions, and they identified, okay, this person is currently not a citizen. A lot of times what was happening, or what was suggested, was that they would be offered citizenship by simply joining the military. And that is, it's not accurate. It might be a ploy being used. It might be something to get somebody to sign on the dotted line.
And I agree with you. We don't want that kind of a fraudulent offer made, but I'm just saying from an Ed Perlmutter perspective, they've gone in, they've served, they've done all we asked. Now, they may have violated this, that, or the other thing. Okay, we've got criminal courts and jails to deal with that, but it isn't that they still got to go through the process to become a citizen.
And they should.
And they should,
that's one of our points.
but in my
Right.
mind, they've got a higher status.
Well, they certainly would have the wherewithal and the ability as somebody that's functioning as somebody of the military to be able to say, how do I become a citizen? and do it within a shortest period of time as possible. And I think that's what the discussion was. We don't want to short circuit that and say suddenly you join the military, you're serving honorably, and boom, you're a citizen. Because I think it avoids kind of what we've been talking about, which is, in a lot, to be honest with you, a lot of the amendments that were offered in judiciary were very specific to certain crimes. And we got, there was a number of them that were offered, I think. And some of them, obviously were offered just to be rejected. But I think that,
I
it's
promised the
important.
chair that I was not going to
Yep.
talk a lot. I've already gone over my time. I'm
Yep,
going to yield
sorry.
back to the chair.
Dr. Burgess.
Thank you, Mr. Chairman. Mr. Chairman, can I just ask you, you said in your opening remarks, we are going to be considering the NDAA today?
We are not.
We are not. Okay. May I just further inquire, are we going to be given the 72-hour time frame to review it between the time it is introduced and we vote on the floor?
We will work something out with you. I'm not going to give you an ironclad commitment to that, but when the text is available, we will give you the information.
Okay. Well, I would refer you back to what's called the McGovern rule. Okay.
No, and I want to refer you to the fact that, 90% of the time we've followed it, and I will compare that to when you were in charge.
Well, and that's an interesting point, because Mr. Fitzgerald has pointed out when we considered the marriage bill in September, it introduced the same day it came to Rules Committee, we voted on the floor the next day. Fairly significant bill that you had not had time to discuss and evaluate in your Committee of Jurisdiction. Now, since that day in September, have you had additional hearings? Were you able to review the language that we're going to be putting on the floor today, or tomorrow, rather?
No.
So we're essentially in the same situation with that. As Mr. Ranking Member Cole brought up, an improvement over where we were in September, but still, I'm just a humble backbencher in the United States House of Representatives, and I depend upon my colleagues, both Democratic and Republican, in the Judiciary Committee to evaluate these things and make certain that we're not harming people with our legislative activities. But you've really not had the additional chance to do that. Is that correct, at least as a formal committee hearing?
No, and I know Chairman Adler's with us today. Not that I remember, was there any significant kind of deep dive into that issue in a regular hearing and then ultimately, kind of votes taken, so, no.
Well, let me just ask you on something that has come up. Family Research Council has done an evaluation of the bill, and as part of their evaluation, they discuss Section 6A, and they say it only protects against being forced to perform same-sex marriage if you are religious enough. This narrow protection includes only religious clergy in the performance of a wedding and excludes nearly everyone else. Is that a fair reading of Section 6 of Senate Amendment to H.R. 8404?
Yeah, I must admit, I haven't seen that language before. You just brought it up, but it appears to be, and I think that's something that obviously is being discussed, and it's been part of the national debate that's continuing right now, so.
Can I intervene here on that point?
I'm hearing voices. Yes.
Thank
Yes,
you.
of course.
Section 6A reads in its entirety as follows. Nothing in this act or any amendment made by this act shall be construed to diminish or abrogate a religious liberty or conscience protection otherwise available to an individual or organization under the Constitution of the United States or federal law. It's not a question of enough. And nothing in this act or amendment shall be construed to diminish or abrogate any religious liberty. And that's why most church groups in the United States, and I'll give you some examples, the United Church of Christ, the Unitarian Universalist Association, the Catholic Social Justice Lobby, National Council of Jewish Women, Muslims for Progressive Values, the Anti-Defamation League, the Episcopal Church, the Evangelical Lutheran Church in America have endorsed this bill. None of them would have endorsed it if this put any kind of limit or restriction on their liberty, obviously.
Well, I don't disagree with what you're saying, but as a practical matter, there's a significant schism within the Methodist Church in Texas right now, and there are a number of parishes that are looking at separating from the mainstream body over this very issue. But again, Mr. Chairman, I will ask that unanimous consent, this letter from Family Research Council be made part of the record. But
If I objected, would you read it?
yes, I'd be happy to.
I'm not going to object. Right. Without objection.
Still, they raise the concern that the protection only exists if you're religious enough. And then the question in my mind comes that if you've got half of the parishes in the Methodist Church in the state of Texas that are separating, what is going to define being religious enough? So I think that's still an unsettled question. I wish it had been perhaps more thoroughly looked at by the Committee of Jurisdiction before the Senate amendment comes to the floor, but I guess that's where we are. Now, let me just ask another question.
I must say, it may be that some people in Texas are misreading the law, and to say, you know, you have to be religious enough. But again, the law is one sentence. It doesn't say anything about religious enough. It says nothing in this act or any amendment made by this act will be construed to diminish or abrogate a religious liberty or conscience protection otherwise available to an individual or organization under the Constitution of the United States or federal law. That's absolute. It's not conditional. It doesn't say how religious you have to be. It's absolute. And if there are some, which is why most churches in the United States have endorsed the bill, with this Senate amendment in it. And if some people are misreading it, that's their problem.
Yeah,
I don't think the question is debatable.
I don't have a transcript of the Supreme Court's discussion of this in front of me, but I would just submit that there is some ambiguity there, and I don't think the legislative language actually eliminates that. In fact, my opinion is it opens the door for that. Let's just, if we can, move on to the Eagle Act, and I would ask both of you if you're familiar with the story that was out there probably 5 or 6 or 7 years ago about Disney employees. There were 250 Disney IT employees that were laid off and required to train their replacements. They brought a lawsuit against the Disney company. Eventually, a federal judge found that basically the outsourcing companies said that the law would only apply to them if the American workers who were displaced by the visa holders had originally been their employees, that is, employees of the outsourcing companies and not the Walt Disney Corporation. Judge Presnell was persuaded by that argument, but that is the type of story that when ordinary Americans read that, they don't understand why they cannot have the full protection of law, and furthermore, why Congress would be passing a law that would advance people who are going to take their jobs, and then they're forced to train them if they're to preserve their severance package and not find themselves a subject of a blacklist. If either of you cares to speak to that, but I don't think the language we've got in the bill in front of us today would prevent that from happening.
I think it would help. And if I may, it was not just Disney, but also Southern California Edison engaged in the same kind of a wrongful activity, and the University of California, San Francisco also engaged in that same wrongful activity, and we called them on it, and they all had to reverse. Here's what we've done, and having said that, I'd like to do more on H-1B reform than is in this, but here's what we have. It would be a ban on primarily recruiting H-1B workers for open positions. So right there, you wouldn't allow Disney or Southern California Edison would not be allowed to go out and recruit H-1B visa holders to supplant their workers. Similarly, a ban on advertising only to H-1B workers. A huge increase in the fines for violations of worker protections, an expansion of DOL's authority to audit, and prevailing wage provisions. Now, H-1B workers in the Disney case, and that was a number of years ago, as was the Southern California Edison, were being paid less than the American workers. Well, that was the prevailing wage. That's why they did it, to save money. Well, under these rules, you could not do that because you have to pay the prevailing wage, and if you don't, the fines will make up any dream you ever had of saving money. So I agree with you. Those things should never have happened, and I think there are some protections in this bill, although I'm hoping that on a bipartisan basis, perhaps in the next Congress, we can do even more. And Congressman Issa and I have talked about trying to do that in the next Congress, and I'm hopeful that we can.
Mr. Fitzgerald?
I didn't have any, I vaguely remember the Disney stuff, but I didn't have a specific comment. I'm not sure if it tightens it up or not, if the bill tightens that up or not.
So it wasn't part of the discussion during the hearings?
Not that I recall, not that I recall. The Disney stuff, I don't
Well,
know.
Disney was years and years ago. It was a wrong thing that happened. We didn't discuss
October of
Disney. but-
2016. I mean, it's
Well, that's
recent enough that some of us can
8
remember
years
it.
ago. But there was a discussion of the H-1B program, and that's when Congressman Issa and I agreed that we would try and work on further reforms.
Well, the reason the plaintiffs lost the case was because they weren't employees of the contracting agency who was actually bringing in the H-1B visa employees. So it seemed a little convoluted, and seemed like the protections that should have been there weren't there. Now, if you tell me that they are there in this current language, I'm happy to review that and see if that is in fact the case.
If I may, I want to make sure, I think this is better, but let me be clear, I think further, this is not a vehicle for a complete revise of the H-1B program, but I do think it merits additional review. I don't want to purport that this is everything we need.
Well, I'll continue to review that with staff before we have to vote tomorrow. Ms. Lofgren, you made the comment that, broader, perhaps revision of immigration laws needs to happen, but you know the problem. And it goes back to long before I was ever in this House, but in 1986, when President Reagan signed the Simpson-Mazzoli Act. And I, as an average citizen, was told that, hey, we'll do this amnesty, and then by golly, we're going to get the security side right, and we won't have this problem in the future. And my constituents back home say, what in the world would you be even considering any type of immigration reform until you get the border security that we were promised in 1986, which has never been delivered? Reference the chaos, Mr. Fitzgerald, that you have pointed out, and even as we speak, the thousands that are coming across unchecked over our southern border, and additional problems being imported vis-a-vis the fentanyl problem that has caused 120,000 deaths in this country the last fiscal year. So until the security problem is resolved, and Secretary Mayorkas testifying before Congress under oath that the border is secure, I'm sorry, that doesn't get it. The metrics are such that the border is not secure, and you cannot have any sort of immigration reform discussion until you fulfill that end of the bargain. And I'm happy to yield to Ms. Lofgren or
Sure.
go back.
I was not a member of Congress in 1986 either for the Reagan amnesty, but one of the defects of that is that it failed to account for the needs of the U.S. labor market, and we have now ended up with half of the farm workers in the United States are undocumented, and there is not a line out the door of U.S. citizens to go pick those crops. That's one of the reasons why we had the bipartisan Farm Workforce Modernization Act that would meet the needs of American farmers, and it's got broad support from the American farmers. It's got broad support from the United Farm Workers Union because it ought to be legal. We want immigration that meets America's needs to be legal and orderly. And I think if you can do that, then you help create a situation where you can have order. And if you just say, well, we're not going to do anything, then we won't get that order. We know some people, immigration ought to be orderly and it ought to serve the interests of the United States. And I think in order to do that, reform of our laws is necessary, and I thank you for letting me address that issue.
Well, again, until you can demonstrate a modicum of control, you're not even going to be able to have that discussion. Mr. Fitzgerald, did you have something you wanted to add?
Well, I would just say I agree that that's a laudable goal, but if you've been to the San Diego sector and you see the amount of cocaine and fentanyl and weapons and cash that's being housed there as a result of the smuggling that's going on, the Ninth Circuit has ordered all of these things to be held because they're evidence in these smuggling cases. It's overwhelming what's going on down there. So that may be a laudable goal for full reform, but if we don't stop that now, the train of drugs and guns and cash coming in, making their way to Denver and be disseminated across the nation into all of our districts, that has to stop, and it has to stop now, or we're not doing our job here. So that would be the difference, I would say.
I would just note for the record, all of us are opposed to drugs coming across the border against the cartels and the like. There's no
You'd never know it. Thank you, Mr. Chairman. I'll yield back.
Okay, all right. Mrs. Torres, did you want to add anything, or?
Yes, Mr. Chairman, just permission. I would like to request unanimous consent to submit my comments for the record. I know the hour is late.
Without objection. Ms.
Thank
Fisher?
you.
That caught me off guard. That was so easy to do. But just wanted to touch base with a couple of things. And Mr. Fitzgerald, you mentioned earlier regarding the name of the bill and the Veteran Service Recognition Act. And I just had to point out that last week we had one of the other members in here offering an amendment to the rule to I think, eliminate. I can't remember if it eliminated or just or strongly discouraged naming bills that don't, when it doesn't have anything to do with what's in the bill. And so I thought it was interesting that you pointed out, because that's something that other people recognize. Just going back a little bit, Mr. Fitzgerald, to the issue Mr. Perlmutter was mentioning about, if they've served, they should be, allowed to become citizens. But I think that, and you mentioned earlier some amendments that were offered in committee, and Mr. Issa had an amendment that would have required that if they were dishonorably discharged, then they would not, as I recall. Am I getting that correct?
Yeah,
And so I was just
that's
kind of,
right.
as Mr. Perlmutter was talking about it, I was concerned, because I thought, well, if we're just going to do this blanket, then maybe we should specify honorably discharged. And correct me if I'm wrong, Mr. Fitzgerald, this bill does not do that. You don't have to be honorably discharged to.
That's right, that's right. What,
This dishonorable discharge is excluded.
Thank you, but I'm asking Mr. Fitzgerald.
no, if you've got somebody that you think falls into that category, I mean, what we were trying to demonstrate with the amendments we were offering was, and there's still a list of these, that were all rejected. Human traffickers, non-citizens who unlawfully voted to receive a path to citizenship was a Biggs amendment. Automatic return to the U.S. required by law of individuals who have already been deported, regardless of reason, Johnson Amendment, that was rejected. Drug traffickers to receive a path to citizenship, domestic abusers to receive a path to citizenship, convicted criminals of obstruction of justice, perjury, or bribery, and then illicit firearms. And then the one that had come up numerous times, a serial drunk driver. So, I mean, all of these amendments were offered, as you remember, in judiciary, and they were all soundly rejected. So if they weren't going to be taken, I'm not sure how they would be addressed in the overall bill at this point, I guess.
And Mr. Fitzgerald, don't you think that, and I think that Mr. Perlmutter was getting at it, is at the bare minimum, they should have an honorable discharge. It should not, I mean, period. I mean, I know there's other varying degrees, but it should be honorable.
You would hope that somebody that would enlist, or somebody that makes their way into, you can make your way into an ROTC program at a university, that at some point, that person would be informed that, there is a path to citizenship. and here's how you become a legal citizen of the U.S. Not to short circuit that and say, okay, you're now a member of the military and you're also a U.S. citizen without doing that work. And this seems to want to change that dynamic, so.
But I think if we're asking, you know, if we're going to be offering this path, their service should be to a point that they are honorably discharged. I guess that's my point, because they are receiving, a special benefit.
Yeah, I did not remember it, but apparently, Mr. Isa did offer the honorable discharge amendment, and it was rejected.
Thank you. And just, I think, one other issue, I think Mr. Cole was asking questions, and you had said something to the effect of this is very broad, the ability for DHS to the authority for them to offer this to individuals is very broad, and I'm just
Right.
wondering.
Under the bill, DHS Secretary Mayorkas would have the authority to prevent the removal of an alien who served in the military decades ago, but who otherwise would be removable based on convictions for serious crimes. So it once again creates kind of this area where I think it's confusing as to whether or not this person should be deported and whether or not they would qualify. So
Well,
it's an issue.
and Mr. Fitzgerald, if you have anything that you wanted to add, I would be happy to hear it. But otherwise, I just think that there's so much more work that needs to be done on this bill to make it clean, because we are, we're offering citizenship, and I think that we need to make sure that the kind of people that make sense, that if they're
Yeah,
service.
I mean, my experience would say if people can, if members of Congress sitting in a hearing can continue to come up with anecdotal examples of, well, what if this happens, or what if the person falls into that category, that oftentimes the bill's not ready for prime time. And that's kind of what I think we discovered that day.
And then we offer broad authority to DHS to do what they like, and that's an issue. And with that, I
Thank
yield
you.
back.
Mr. Raskin.
Thank you very much, Mr. Chairman. I want to speak in strong support of the rule, and I'm very glad that we're bringing in the legislation from the Senate to defend the marriages of gay and lesbian Americans today. In 2015, in the Obergefell decision, the Supreme Court struck down discriminatory state laws that kept millions of gay and lesbian citizens from getting married. And the court determined that this was a plain and outrageous violation of the substantive due process right to get married, the right of privacy that everybody has to make decisions about their personal lives, about procreation, about reproduction. And so that's been the law of the land since that took place. And that was a great defense of marriage and a great expansion of marriage rights, and it stabilized and grew the institution of marriage in the country. But now this year, in the Dobbs decision, the Supreme Court, of course, undid more than a half century of precedent protecting the reproductive rights of women in the country. And Justice Thomas snuck into the opinion his belief that he wants to reverse the flow of the dominoes so that a bunch of privacy rights fall. And it's very clear that the right wing is targeting the constitutional right of gay people to get married in the country, which they have never accepted. And it is surprising indeed to hear from some of our colleagues that, well, we should just be content and accept their assurances that nothing is going to happen to the right of gay people to get married, which was precisely the assurance that they gave to us about the right of women to choose to access an abortion under Roe versus Wade in consultation with their physicians and their husbands or their partners and their families. And that was precisely the right that we were told for decades, oh, don't worry about it, this is never going to happen. Then, of course, after the Supreme Court was packed by denying the right of one of my constituents, Merrick Garland, even to a hearing when he was nominated to the Supreme Court, when they packed the court and then struck down the right to choose. Now, it looks like the whole constitutional right to privacy is unraveling. And I'm glad that there is a bipartisan piece of legislation coming out of the Senate with support from all the Democrats, and I think you said, Mr. Chairman, 12 of the Republican senators, protecting the validity of marriages that are performed in states that have marriage laws, and repealing the Defense of Marriage Act, which was passed in 1996. And what's amazing to me, as I intuit that some of our colleagues might not be supporting this, is that this legislation embodies the perfect compromise situation, which is everybody has equal rights in the country. Both the straight people and gay people can get married under this legislation, and everybody's marriage is valid according to where it was performed, and states have to respect, under the full faith and credit clause, marriages that are solemnized in other states that recognize a right that they may not want to. But then also, there's a statement that no church, no synagogue, no mosque, no religious organization in the country must perform any wedding or any marriage that it doesn't want to, absolutely protecting their right to make that decision. And also adding a clause, which I read as a kind of anti-retaliation clause, that they cannot be the subject of any kind of discrimination or retribution if they decide that their church doesn't want to perform those kinds of marriages. That compromise, which garnered the bipartisan convergence over on the Senate side, absolutely tracks what the U.S. Constitution says and what the court said in the Obergefell decision, which is basically the church decides who's going to get married in the church hall, and the Constitution decides who's going to get married in City Hall. So you might not like same-sex marriages, you might not like interracial marriages, you might not like interfaith marriages, fine, but under the law, everybody's got the right to do it. And you can join whatever church you want, and that church can make whatever decisions it wants about who to marry and who not to marry. So I've not heard a single credible or coherent objection to this compromise that came out of the Senate, and I would hope that we would give it our unanimous support and bring it to the floor, and I would hope that the House could unanimously endorse it, because this is precisely the compromise that is contemplated by the framers of the Constitution. Remember, when we take our oath of office, we put our hand on the Bible and we swear to uphold the Constitution. We don't put our hand on the Constitution and swear to uphold the Bible. It's the Constitution that governs here when we're talking about the civil rights of the people in secular institutions. But within, it's totally up to the church. If they don't want to marry gay people, or they don't want to perform weddings for interracial couples or interfaith couples or people who don't belong to that church, they don't have to. And that's what this legislation says, so I think we should support it strongly. I also want to thank our colleague, Ms. Lofgren, for her excellent work on these bills, and I'll yield back to you, Mr. Chairman.
Thank you very much. Ms. Scanlon.
Thank you. Looking forward to voting for the Respect for Marriage Act again. It's not just about respect for marriage, it's about respect for our fellow citizens. And I also am grateful to Rep. Lofgren for pushing forward some legislation to begin to address the problems with our immigration system. Sitting back and doing nothing is certainly not a solution that's worked for us. I yield back.
Thank you, Mr. Morelli.
I too want to thank Chair Lofgren for her work on this important subject. I have many employers in my region who very much, particularly in technology, where they're struggling, and there are engineers and technicians and people work in software and work in photonics and work on integrated circuits, and continuing to look to address labor shortages, and this will help to address it, so I'm appreciative of that. And I want to thank my colleague and fellow New Yorker, Chairman Nadler, for his work on the Respect for Marriage Act. I appreciate my friend and colleague, Mr. Raskin, who I think said much of what I wanted to say and intended to say. I'd only add this, that in 2011, I was honored to help pass legislation making New York State one of the first to legalize marriage equality, and I believe passing Respect for Marriage Act in Congress would mark another critical step in our efforts to fill what I believe is our fundamental foundational promise
of endowing all Americans with the same equal rights and opportunities. So again, thank you to Chairman Nadler for your efforts to ensure every American has the dignity, respect, and equality they deserve. With that, Mr. Chairman, I yield.
Thank you very much. Ms. Ross.
Thank you, Mr. Chairman. I will be brief. Again, I want to thank Chairman Nadler for bringing the Respect for Marriage Act forward. I want to remind the committee and whoever might be watching this on WebEx that most of what that bill does is repeal a law that the Supreme Court found to be unconstitutional. That is our job. It is the Supreme Court, as of today, found that law to be unconstitutional, so we should get it off of the books and recognize the mistake that was made by previous Congresses. I also am very proud that both of North Carolina's Republican senators voted for the bill and recognized that love is love. And then finally, I want to thank Chairwoman Lofgren. I represent the Research Triangle area, as you know. Her bill will do so much, the EAGLE Act, to help our employers, to help people who have contributed to the economy of North Carolina and our country. And I want her to know that the Chamber of Commerce is thankful for that. And thank you, Mr. Chairman. I yield back.
Thank you. There are no other questions for this panel. Thank you very much. You're free to go. We now have amendment testimony from Mr. Roy of Texas. Mr. Roy, you may proceed.
All right, thank you, Chairman. Sorry about that. I had to get situated. Appreciate the opportunity to visit with the Rules Committee today and offer an amendment to the legislation, which mirrors the amendment and the legislation that was offered by my friend Senator Mike Lee in the U.S. Senate. It is something that I believe is extremely important, that we have the ability to debate in the United States House. We have not had any hearing in the United States House, in the House Judiciary Committee, on this bill, or on this amendment, or the ability to debate it in full. We rushed this bill through in July, allegedly in some sort of emergency setting because of some words that Clarence Thomas penned. And so it was an emergency that we passed this in July. It clearly wasn't political. It was an emergency. And here we sit, having no debate in the United States House Judiciary Committee, having had no serious debate on the floor of the House. And here we are again, about to have no serious debate in the House Judiciary Committee or no serious debate on the floor of the U.S. House. It'll be another perfunctory exercise in this body where we bring forward legislation that has enormous consequences, where we drop it on the floor of the House, and we say vote up or down, and then go give speeches. And that's what we'll do, and we'll jam it through, and this is why the House of Representatives is badly broken. So I'm going to offer the amendment. I know the result. You all know the result. It will get not only either voted down, I'm told it's going to be ruled out of order because it apparently has some, it is said to violate, I think, Rule 10A or whatever it is with respect to having an impact, and allegedly that has an impact with respect to deficits. As I read the rule, what I saw out of the CBO was that it would raise revenues but also have expenditures, but it doesn't actually say anything about having deficits, which is what the rule actually says. But I would only say to the committee that there is only one way that this could technically violate said rule, is if it's effective. That's the only way, is if the amendment is adopted, is effective, and actually has damages as a result of the AG taking action and people bringing suit and getting damages, it's the only way that it can actually have a cost that would raise deficits. So think about that. We're going to block an amendment because it technically violates a rule with respect to deficits because it might be effective. I offer the amendment for a variety of reasons. Right now, as we know, the legislative branch has been neutral on the issue of same-sex marriage, at least as in terms of its stated position. Obviously, we have the Obergefell opinion. This bill barrels us into the space that's not actually being threatened, in my view. Obviously, my colleagues think that this is necessary because of the words penned by Justice Thomas. I heard my friend from Maryland discussing that it was necessary. But the reality is what Justice Thomas said was more questioning how the rights came into being, not the what. Justice Thomas, in fact, brought up the fact that it could be privileges and immunities instead of substantive due process. He brought up another number of ways he could get there, and this is hardly anything new by something that Justice Thomas has put out in his jurisprudence and his doctrines previously. This bill, as amended, in my view, does not adequately protect people who have closely held religious or moral beliefs from going about their own lives. In my view, for example, Section 6, which one of the members of the committee brought up as having offered some significant protections, is basically just stating a truism, that the Constitution exists and RFRA exists. But it does nothing to actually, in the end, protect all Americans from the sword that is being provided in this legislation. And I would also offer and remind the committee that this body passed legislation off the floor that did not have any of these religious liberty protections that the Senate added, which are limited and do not actually cover the gamut of the religious liberty that needs to be protected. The fact is, the House rushed it through with no hearings, sent it over with no religious liberty protections in the legislation, and still had the sword of the private rights of action. Kicked it to the Senate in a rush. The Senate then adds in, I think, half protections. And now, instead of having a robust debate here, perhaps going into the House Judiciary Committee and having a robust debate about how we could ensure protections for everybody, we're going to have it killed here on a technicality and, frankly, on the substance, even if it weren't for the technicality. And we won't even have a debate on the floor of the House for a full measure of robust religious liberty protections. In what universe is this the way we should be doing business? Indeed, people with closely held religious beliefs are not actually protected by this bill, in my view. It does nothing to protect, for example, Lori Smith and the 303 creative case that are being argued right across the street today in the United States Supreme Court. Jack Phillips, known as the cake baker from Colorado. Dr. Andrew Fox in Austin, where I live, a volunteer fire department chaplain who was fired from a volunteer position for volunteering his views about traditional marriage and or about gender roles and boys swimming against girls, for example. We've seen the effects of laws like this in Finland, where a member of the parliament, Päivi Räsänen, a member of the parliament, was dragged through a court for sharing her beliefs about same-sex marriage 20 years ago on a pamphlet. This is coming to a theater near you, ladies and gentlemen, and this legislation, supposedly with religious liberty protections, is going to be the sword that is going to come after you. Because notwithstanding what my friend from Maryland just opined, it does not provide the robust protections that are necessary to ensure the full protections of the First Amendment to which we are due as citizens in this country. In fact, not only are these people not protected from the effect of the bill, but they will actually be targeted under this bill by trial lawyers in the Attorney General's office. Section 4B allows the AG to bring suit against any person who violates a right or claim rising from such a marriage while under the color of state law, a not defined term, and arising from such a marriage. What does that even mean? Section 4B allows any person to bring suit against another person for the same, even if people's religious beliefs had a suit brought against them and they won on the merits. We often see long and expensive suits ruin businesses and lives in the process. If we actually want to protect everyone's First Amendment rights, I believe we must pass the amendment that I'm offering here today. And if you think this amendment is superfluous, there's no reason not to put it forward for a vote and let the body decide. I don't see what the harm is in offering legislation and offering an amendment which would expand protections for religious liberty if our concern here, as the gentleman from Maryland said and others, is that we want to ensure that we've got protections for religious liberty. I appreciate the chairman giving me the time here today. I know it's late in the day because there was a longer panel. But I cannot, for the life of me, understand how we're going to take up such an important issue and never having gone through the House Judiciary Committee before actually debating it, and now offering an amendment that is worthy of debate to ensure full protection of religious liberty for the American people, and not have the ability to actually debate it here, frankly, even in rules, because it's going to get killed on a budget issue. And with that, I will yield back to the chairman.
Well, thank you very much. We appreciate you being here. I personally believe your amendment is duplicative and unnecessary, but he's correct. The gentleman's correct when he says it violates at least one budgetary point of order. And the point of order ruling is not something that we've come up with out of the air. It comes from the parliamentarian and from CBO. The Senate spent months crafting a bipartisan compromise to amend H.R. 8404 to address the religious liberty concerns raised by Republicans in the House and Senate. Sections 6 and 7 of the legislation ensures that there's no impact on religious liberty. And I think if we would have, which I think we're not going to do because it does violate a point of order, but I think it would unsettle the Senate's carefully crafted compromise. It would obviously probably derail action on this bill. And the gentleman said, he maybe wasn't here when at the beginning of the previous panel, but he said, oh, we acted like it was an emergency. Absolutely. When you're faced with a Supreme Court, many Republican judges who assured time and time again, Democratic senators and Republican senators, that Roe versus Wade was was established precedent, and then they turn around and basically take away a women's right to choose and obliterate 50 years of what it was established law in this country. And then when you have Clarence Thomas opine about marriage equality, you bet your life many of us think that this is an emergency. Many of us think that the Supreme Court is working overtime to try to turn back the clock on so many rights. So, yeah. But if the House passes this legislation, which I expect and hope that it will do, it will go right to the President's desk and become law. And there are millions of people in this country that will have the peace of mind knowing that it has become law. And so I think that, this House has gone through this bill has gone through both the House and Senate. I believe it needs to be signed into law as soon as possible. And without objection, I'm going to ask unanimous consent to insert into the record letters in support of this legislation from the Interfaith Alliance, U.S. Jewish organizations, and from 8 leaders of faith-based organizations representing tens of millions of Americans and hundreds of religious institutions. And I'm happy to yield to the gentleman from Oklahoma.
Thank you very much, Mr. Chairman. I just want to associate myself with my friend from concerns about process here. He's exactly right. We didn't debate the last version of this bill, didn't go through committee. We're not doing this version of this bill. We passed the one in July because it was quote-unquote an emergency, but evidently it wasn't because nothing's happened and that bill isn't becoming law. We have something different. It's better, and the only reason, why it's better? Because it actually went through something of a process over there. Our process is not that one house draws something up and the other house accepts it. Both houses look, and then we go to conference, and then we have a better product. So we've seen a lot of that this Congress, and I regret that very much because I think it destroys people's confidence in the process itself and their belief that all points of view are going to be considered and you'll have a thorough debate. But again, that's my point of view.
Thank you.
Will the ranking member yield?
Certainly yield, my friend.
I would just ask, and I will send it to staff, there's a list of 83 groups from Alliance Defending Freedom to the Billy Graham Evangelistic Association, a Concerned Women for America, a host of religious organizations, a host of church organizations and religious organizations, 83 of them that have expressed concerns that this would trample on religious liberty rights. I'd like that inserted in the record.
Appreciate that.
And I'll say without objection.
Yeah. Thank you, Mr. Chairman.
Mr. Perlmutter.
No questions. Thank you for your testimony.
Dr. Burgess.
And I appreciate the gentleman's testimony as well. I appreciate you referencing the concern I had over Section 6 in the bill and the concerns brought to me by Family Research Council. Mr. Chairman, I'd just point out that we are the all-powerful Rules Committee, and we can waive points of order. Of
course.
We do so with regularity. I dare say we're going to receive the text of a rule here in a few moments that will waive some points of order. So it is certainly within our power to waive whatever budgetary point of order there is and allow the robust debate that Mr. Roy seeks. And here's the thing, the letter that was sent to us by Chairman Nadler of the Judiciary Committee asked for a closed rule on a bill that never had a hearing in the Judiciary Committee, passed the Rules Committee under an emergency procedure earlier this year, and now many months later has come back to us from the Senate. Why would you have a closed process for this? If nothing else, we should have a structured rule, allow debate on what Mr. Roy has.
Would the gentleman yield? I'll explain to you why. Because if we were to amend this and it goes back to the Senate, for all intents and purposes, it's dead for the year. And many of us believe that we have a court right now that is hell-bent on trying to reverse the rights for the LGBTQ community, and we do not trust them to respect the marriage equality in this country. So that is why. So that's where we're coming. When in January comes along, the gentleman's party will be in charge, and you can bring one amendment after another to reverse the last 70 years of social progress, if the gentleman prefers. And we will oppose you on that.
Reclaiming my time from the chairman, there's no evidence of the Armageddon that he describes being at the doorstep. But Mr. Roy, you looked as if you wanted to say something.
Well, I would just say, if the amendment is unnecessary, then it will fail on the floor of the House, and you have no concern about bouncing it to the Senate. If the amendment is important and would pass on a bipartisan basis, by the way, it was a bipartisan amendment in the Senate, and it was a close vote in the Senate. It would be important for the People's House to express its will of full protection of religious liberty for the people of the United States on such an important issue as marriage, and as expressing religious liberty and the ability for people to speak freely about it. Again, I reiterate, a member of parliament was prosecuted in Finland for a statement made in defense of traditional marriage made 20 years ago. Is this where we're headed? Is this the direction that this country is going? Because if it is, we're going to be shredding what little there is of the fabric holding us together in a union in which we can agree to disagree. And the fact is, the amendment is offered in good faith, as it was by my friend from Utah, Mr. Lee, and was, of course, voted down. It did have bipartisan support, acknowledged, and I think it would be an important amendment to just offer on the floor of the House. You know how it'll work. We'll get an hour of debate on both sides. The amendment will almost certainly get voted down, but I hope it wouldn't, because I believe it's important. I'd like to have at least the opportunity in the 1 hour of debate that I would get in this august body to be able to make the case for religious liberty with my colleagues. I yield back to the gentleman from Texas.
And I thank the gentleman. Mr. Chairman, I also have a couple of unanimous consent requests. One is I referenced the schism in the Methodist Church in Texas, and I'd like to submit for the record this article from the Texas Tribune.
I won't object to anything you want to insert in the record.
I'd be happy to read it, but.
I'm giving you the courtesy of.
And then earlier, I referenced a New York Times article about the Disney visa layoffs, and I would also ask unanimous consent. I didn't earlier, but I'd ask you.
Without objection.
Both those be part of the record.
Without objection.
Thank
you. Mr. Promoter, you have? Okay, I'm sorry, okay. Ms. Torres, okay. Ms. Fishbach?
Thank you, Mr. Chair. And I just wanted to, I guess, associate myself with the remarks of my colleague from Texas in particular, and I think Mr. Cole expressed it also as the issues with the process. This is a important piece of legislation to the majority, and that they would push it through like they did without having any kind of input from the members of the House of Representatives seems like a bad way to handle something if you see it as so important. And you know, I think that when we talk about whatever it was in July, that it was an emergency.
Yeah.
You know, cases have to appear before the court can make a decision, and that takes months, years, very long time to get it there. So I don't see that there was an emergency. There wasn't something sitting in front of the court that they were going to be deciding on. And so I think that that's a little bit, overstated when you say it was an emergency. And I really am concerned, and I think we've said this repeatedly in the Rules Committee, is the process has been horrible. Just over and over, things being rammed through. And I have concerns, and I think that, Mr. Roy has a valid argument that says give him an hour to argue it on the floor and let the body decide. And with that, I will yield back.
I have a good idea. I'm not sure who's going to handle the rule on the Republican side, but they can yield you the entire half an hour to make your case, if you want to do that. And I'm sorry that the, I'm sorry that the.
For an amendment that's not in order?
Well, I'm sorry that that my friends don't think this is an emergency. I have constituents that think it's an emergency. That, quite frankly, are frightened out of their mind by the behavior of the Supreme Court after the Dobbs decision. And so, look, I mean, this may not be a big deal to some of my friends on the other side of the aisle. I assure you it is a big deal to many of us on this side of the aisle. Mr. Raskin.
Thank you, Mr. Chairman, and it's a pleasure always to see my friend from Texas, Mr. Roy. And I wanted to just ask a couple of things. One is, he posed the question of whether we're headed in the direction of Great Britain, where he reports a case, which I'm unaware of, about someone being apparently prosecuted or punished for, anti-gay speech or something. I don't know what he's referring to there, but I can guarantee you that there's nobody who has been prosecuted for saying that they're opposed to the Obergefell decision or they're opposed to same-sex marriage. That's perfectly covered by the First Amendment. In fact, you could say you're opposed to our whole Constitution, which Donald Trump said yesterday, I think, and that's completely within his First Amendment rights. Of course, you can't incite a violent insurrection against the government as President of the United States, which is moving from speech to action, but he's made himself clear that he's opposed to the Constitution of the United States. But so I don't know whether there are any American cases, Mr. Roy, that you were referring to, but if there is one, I would love to hear about it. I would be far more reassured by our colleagues who keep telling us, like Mr. Burgess, not to worry about the Armageddon of the Supreme Court overturning the Obergefell decision and trying to strip away the right of gay people to get married in America, if they also told us they were opposed to that. But it seems like the people who keep telling us not to worry about Armageddon are the same people who are trying to make Armageddon arrive. So if any of them would say, well, don't worry, Justice Thomas didn't really mean it, or he doesn't have the kind of influence with Alito and the other justices that we think he has, but in any event, I'm with you in standing up for Obergefell, then I could feel a little bit better. But I'm not going to accept assurances from people who are working to overturn the right of gay people to get married in America. But I wanted to ask my friend, Mr. Roy, this question, which I thought was so interesting in the beginning, when he seemed to concede that his amendment violates PAGO, and therefore what he describes as a technical budgetary threshold issue in trying to become an amendment. And then, but then he says, well, the only way it would violate is if the amendment works. But isn't that always the test? Isn't that always what we ask ourselves when someone offers an amendment? If this amendment works, would it violate the underlying substance of a rule? So why is that in any way unusual?
Well, but my friend from Maryland, I appreciate the question on that one. First of all, I did not concede that. I conceded that the CBO simply said that there would be revenues, fees, and potential expenditures, but that those expenditures would be tied to success. Meaning success, meaning you created a law and a framework under which American citizens were able to go get damages because the AGs were out of bounds and they won their suit. They won their case. So my point is just not that there isn't potentially a financial impact. I think we're all pretty well aware of my concern about financial impacts when we have bills on the floor. If this were a suspension vote, I'd have concerns about having a cost that's just thrown down on the floor. But I'm saying here, you have the ability as the Rules Committee to make a decision. And, to say that a whatever, $500,000, it could be more, guess by the CBO, and to then kick this out based on the fact that you would have the successful reality of getting the damages is insane. Like, that's the whole point. If we think it's garbage and it wouldn't work, then it wouldn't cost a dime, literally.
All right. Okay, I got you. I got you on that. Let me ask you one final question, which really gets to the heart of the matter, because we seem to have a very different concept of what religious liberty and freedom is, and mine is very influenced by Madison's views as he expressed them in his memorial and remonstrance against religious taxation. And it's about the right of people to worship freely, to pray freely, not to be harassed and persecuted for their religious free exercise. But it's not a right to discriminate in public against other people. In fact, if you go back and you look at the major civil rights cases from the 1960s, the motel owners and the hotel owners and the restaurant owners who wanted to discriminate against Black customers also shrouded their intent in the language of religious freedom, saying, well, it violates our religious principles to serve African American customers, or we don't want to have interracial couples staying at our hotel because that violates our religious precepts. But the Supreme Court determined that when you enter the stream of commerce, you are providing a public accommodation with all of the benefits that you get from society in doing it. You do not have a religious free exercise to discriminate. Your church can discriminate. If your church wants to exclude people of different religions, of course, or different races or ethnicities or interracial, interfaith couples, they can do that. That's what the religion can do. But if you set up hotels and restaurants and office establishments and so on, no, you don't have a right to discriminate against people based on race, religion, ethnicity, and sexual orientation. And I'm just wondering why you think sexual orientation should be different from any other category of discrimination. And I hope you would recognize that people who've wanted to discriminate have always tried to wrap their discrimination in the guise of exercise of their religion. And you're free to comment or not, as you see fit.
Sure, no, happy to. And again, I appreciate the question and always enjoy the give and take. I wish this were in the House Judiciary Committee and we could do it at length. Two things. Number one, with respect to the question, I'm glad the gentleman acknowledges, which is the very truth that's driving my wanting to offer the amendment, which is the protections offered around which my 12 Republican colleagues in the Senate base their support are highly limited, as the gentleman from Maryland just acknowledges, highly limited to, for example, the word, it's the solemnization, it's the act, it's within the church, it's the act of the marriage, of the action of the pastor or the priest or the bishop. It's not to the more expanded view to answer the question of whether or not, for example, the school that my children go to, or that many other folks' children go to, that might be a religious-based school, can you discriminate? Can you make a choice to not hire somebody that's engaged in a same-sex union at your children's school? I mean, that's a debate. That's a question. It's a question whether is this going to be protected or not protected. And I think that's the debate that I would like to flush out, right? That's part of what we're trying to get at. And then the second thing, to answer your question, I realize that there's often the effort to put this together with the issue of interracial marriage. And I understand. I would associate myself, much to the chagrin, no doubt, of many on the committee, with Justice Thomas's footnote 5 from Obergefell, in which he said, the suggestion of petitioners and their amici that anti-miscegenation laws are akin to laws defining marriages between one man and one woman is both offensive and inaccurate. America's earliest laws against interracial sex and marriage were spawned by slavery. For instance, Maryland's 1664 law prohibited marriages between freeborn English women and Negro slaves was passed as part of the very act that authorized lifelong slavery. Virginia's anti-miscegenation laws likewise were passed in 1691 resolution entitled An Act for Suppressing Outlying Slaves. I will save the rest to say that he goes on to say, the traditional definition of marriage has prevailed in every society that has recognized marriage throughout history. It arose not out of a desire to shore up an invidious institution like slavery, but out of a desire to increase the likelihood that children will be born and raised in stable and enduring family units by both the mothers and the fathers who brought them into the world. Final point being, and it has existed in civilizations containing all manner of views on homosexuality. I yield back to the gentleman from Maryland.
Just to interrupt on that second, of course, if you go back and read Loving versus Virginia, you will see that the dissenters wrap their objection precisely in millennia of moral teaching and moral objections under traditional marriage to making Virginia, compelling Virginia to allow Black people and white people to get married, or to allow white people to marry outside of the white race. So I think that the court in Obergefell made exactly the right analogy. All of this is about some people judging other people's marriages and then trying to use the state to interfere with their ability to marry the person they love. With that, Mr. Chairman, I'll yield back to you.
Thank you.
All right, I yield back.
Thank you very much. Any other questions? No other questions, you're free to go. Thank you very much.
I thank the chairman.
You two ought to teach.
Are there any
class
other members
together.
who wish to testify on Senate Amendment to H.R. 8404, the Respect for Marriage Act, H.R. 3648, the Eagle Act of 2022, and H.R. 7946, the Veteran Service Recognition Act of 2022? Hearing none, seeing none, this closes the hearing on these three measures. Okay, at this time, the chair will entertain a motion from the distinguished gentleman from Colorado, Mr. Perlmutter.
Thank you, Mr. Chairman. I move the committee grant H.R. 3648, the Eagle Act of 2022, a structured rule. Rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on the Judiciary, now printed in the bill, modified by the amendment printed in Part A of the Rules Committee report, shall be considered as adopted, and the bill, as amended, shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order only the further amendment printed in Part B of the Rules Committee report. The amendment may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in Part B of the report. The rule provides one motion to recommit. The rule also provides for consideration of H.R. 7946, the Veterans Service Recognition Act of 2022, under a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on the Judiciary, now printed in the bill, shall be considered as adopted, and the bill, as amended, shall be considered as read. The rule waives all points of order against the provisions in the bill as amended. The rule makes in order only the further amendment printed in Part C of the Rules Committee report. The amendment may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, and shall not be subject to amendment and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in Part C of the report, and the rule provides one motion to recommit. The rule provides that at any time through the legislative day of December 8th, 2022, the Speaker may entertain motions offered by the Majority Leader or the designee that the House suspend the rules with respect to multiple measures that were the object of motions to suspend the rules on the legislative day of December 5th through December 8th, on which the yeas and nays were ordered and further proceedings postponed. The chair shall put the question on any such motion without debate or any intervening motion, and the ordering of the yeas and nays on postponed motions to suspend the rules with respect to such measures is vacated. The rule provides that proceedings may be postponed through December 8th, 2022 on measures that were the object of motions to suspend the rules on the legislative day of December 5th and on which the yeas and nays were ordered. Finally, Section 5 of the rule waives the requirement of Clause 6A of Rule 13 for a two-thirds vote to consider a report from the Committee on Rules on the same day it is presented to the House with respect to any resolution reported through the remainder of the 117th Congress.
Heard the motion from the gentleman from Colorado. Is there any discussion or amendment? Dr. Burgess.
Have an amendment to the rule. I move that the committee make an order amendment number 3 to HR 7946 offered by Mr. Biggs of Arizona. This amendment requires that in order for the advisory committee to recommend an exercise of discretion regarding the removability of an alien, the victim of that crime must agree that discretion should be exercised and that all fines, fees, and restitution must have been satisfied. Mr. Chairman, this legislation before us focuses on providing citizenship for those who have been convicted of committing serious crimes. We do have to ask ourselves, what about the victims? This common sense amendment would ensure that the victims have the opportunity to have their voices heard and make certain that any fine, fees, restitution ordered by a court of law have been completed prior to the accused being allowed to return to the country. I urge adoption of this motion, and I yield back.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Burgess amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mrs. Torres. Mr. Perlmutter. No. Mr. Perlmutter.
Torres, no.
Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Ms. Scanlon. No. Ms. Scanlon, no. Mr. Morelli. No. Mr. Morelli, no. Mr. DeSaulnier. Ms. Ross.
No.
Ms. Ross, no. Mr. Neguse. Mr. Cole. Aye. Mr. Cole, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Rushenthaler. Mr. Rushenthaler, aye. Mrs. Fishbach. Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
How is Mrs. Torres recorded?
Mrs. Torres is not recorded.
Torres, no.
Mrs. Torres, no.
How is Mr. DeSaulnier recorded?
Mr. DeSaulnier is not recorded.
DeSaulnier, no.
DeSaulnier, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments. Mr. Reschenthaler.
Thank you, Mr. Chairman. I have an amendment to the rule. I move that the committee make an order amendment number 4 to HR 7946, which is offered by Mr. Biggs of Arizona. This amendment prohibits the secretary from waiving the unlawful voting ground of inadmissibility. Mr. Chairman, this legislation before us today, as it currently is drafted, would enable the secretary to allow individuals who voted illegally to receive the benefits of this bill. I believe we can all agree that any individual who voted unlawfully should not be rewarded. Because of this, the secretary should not be able to unilaterally waive such a serious offense on the grounds of inadmissibility. I urge adoption of the motion, and I yield back.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Reschenthaler amendment. Those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it.
No.
Mr. Chairman, on that, I request a
A
recorded vote.
roll call has been recorded. Clerk will call the roll.
Mrs. Torres.
No.
Mrs. Torres, no. Mr. Perlmutter.
No.
Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Ms. Scanlon. No. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Mr. DeSaulnier.
No.
Mr. DeSaulnier, no. Ms. Ross.
No.
Ms. Ross, no. Mr. Neguse. Mr. Cole. Aye. Mr. Cole, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Rushenthaler. Mr. Rushenthaler, aye. Mrs. Fishbach. Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments.
Mr. Chair.
Ms. Fishbach.
Mr. Chair, I have an amendment to the rule. I move that the committee make an order amendment number 2 to HR 7946 offered by Mr. Fitzgerald of Wisconsin. This amendment prevents the advisory committee from both blocking removal of those convicted of drug crimes as well as granting a green card to an illegal alien who has committed drug crimes. Mr. Chairman, when we are discussing citizenship and the crisis at our border, it is impossible not to make the connection with the ongoing opioid epidemic ravaging this country. This amendment would ensure that illicit trafficking of controlled substances be added to the list of crimes for which a deported non-citizen veteran cannot receive a green card. Additionally, it would preclude the advisory committee from making a recommendation for an exercise of discretion regarding someone who has been convicted of committing a very serious offense. I urge adoption of my motion, and I yield back.
You heard the gentlelady's amendment. Any discussion? Hearing none, the vote is on the Fishbach amendment. Those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
Mr. Chair, I request to record a
A
vote.
recorded vote has been requested. Clerk will call the roll.
Mrs. Torres.
No.
Mrs. Torres, no. Mr. Perlmutter. No. Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Ms. Scanlon. No. Ms. Scanlon, no. Mr. Morelli. No. Mr. Morelli, no. Mr. DeSaulnier.
No.
Mr. DeSaulnier, no. Ms. Ross.
No.
Ms. Ross, no. Mr. Neguse. Mr. Cole. Mr. Cole, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Rushenthaler. Mr. Rushenthaler, aye. Mrs. Fishbach. Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Members not agreed to further amendments? If not, the vote is now on the motion from the gentleman from Colorado. All those in favor say aye. Aye. Opposed, no.
Aye.
Opinion of the chair, the ayes have it. Recorded vote has been requested.
Mrs. Torres.
Aye.
Mrs. Torres, aye. Mr. Perlmutter. Mrs. Perlmutter, aye. Ms. Scanlon. Ms. Scanlon, aye. Mr. Morelli. Mr. Morelli, aye. Mr. DeSagne. Oh, I skipped Mr. Mr.
Aye.
Raskin. Mr. Raskin, aye.
Aye.
Mr. DeSagne.
Aye.
Mr. DeSagne, aye. Ms. Ross.
Aye.
Ms. Ross, aye. Mr. Neguse. Mr. Cole. Mr. Cole, no. Mr. Burgess. Mr. Burgess, no. Mr. Rushenthaler. Mr. Rushenthaler, no. Mrs. Fishbach. Mrs. Fishbach, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk, report the total.
8 yeas, 4 nays.
And the motion is agreed to. I will carry it for the majority. Ms. Fishbach will carry it for the minority. Without objection, the committee is in recess, subject to the call of the chair.